Hello, everyone, and welcome to the webinar, Estate Planning for the Sandwich Generation, Caught Between Kids and Aging Parents. I'm Stephanie Himel-Nelson, and I'm so glad you're joining us today. You're going to learn a lot, I hope, and this is going to be a good use of your time. So for the next hour or so, and I tend to talk a lot, so I'll try to cut it off at an hour, but for the next hour or so, I want to share with you all of the essentials of estate planning. There are a lot of misconceptions out there. So my goal for this hour is to ensure that you walk away understanding what you need in place to protect your minor children and to protect your parents. And the best way to get the most out of your time on this webinar today is to turn off your phone, close your door, close out of Facebook. You'll get a lot more out of this if you get rid of those distractions. So just take this time for yourself so you can learn all of this information and hopefully help your family. Also be sure to try and stick with me for the whole webinar because I have a bonus at the end for each of you and I don't want you to miss it. So you should have gotten an email with the webinar workbook. And if you didn't for some reason, that's okay. You're not going to miss any essential information. But if you do have it, go ahead and print it out and you can refer to it throughout the webinar, and that'll help you stay engaged and make sure you get the most out of the event. So think about your questions as we're going through, write them down in the workbook, and you can ask them at the end. If you're afraid you're going to forget, you can go ahead and drop it in the chat, and I will go back through the chat at the end and hit as many questions as I can. And finally, I want you to think about the people in your life that you care about the most. They're the reason that you're here. We don't do estate planning for ourselves. We do it for the people that we care about. So I recognize that estate planning is not something that's fun to think about. In fact, almost 70% of Americans don't have any estate plan at all. No will, no trust, nothing in place, no powers of attorney. And many of you on the webinar today are probably part of that 70% with no documents in place. But an important question to ask is also, do your parents have an estate plan? Have you discussed their plans with them? Okay, so we're on to question number 1 in your workbook. What are the 3 biggest doubts that people have about estate planning? Now, I understand that there is a little bit of a fear factor in planning for death, that it's somehow going to make it happen. If you keep putting it off, you don't think about it, it's just not something that's going to happen. And we know that this is completely irrational, but this is an objection that I hear all the time from my clients. And it's also a reason that many people are reluctant to talk about estate planning with their parents. Another thing I hear a lot is, this is going to take too long, I just don't have enough time. And I understand that. So we're going to talk about that in this webinar. So you're going to know exactly how long the process takes, what's involved, and how much it costs by the end of the webinar, so you know how to get started. So I also get a lot of questions about how estate planning can really benefit you if you're younger, you're not looking at retirement yet. Isn't this something that only older people like our parents need to worry about? And is estate planning really necessary if you don't have millions of dollars in the bank? And we're going to talk about that too. So if any of this sounds like you or your family, just know that this is totally normal and you are in very good company. So the good news is that I have never had a client sign their will or trust and then unexpectedly die. Never happened. I'm gonna knock on some wood now, just in case. And of course, getting an estate plan in place does require an investment of money and time. But I think that by the end of this webinar, you'll see what the benefits of estate planning are and how they outweigh the costs, both financially and emotionally. And then finally, you'll see as we go through this webinar that the benefits of estate planning really don't have anything to do with how much money you have or how old you are. At the end of the day, when we talk about estate planning, the big picture is that this is not about you. It's not about me. It's about the people that you love the most. So when I think about estate planning, my idea of estate planning is that it's about making sure that things are as easy and inexpensive as possible for your loved ones when you're gone. And you care about that whether you're 25 or 85. And it doesn't matter if you have $10 in the bank or $10 million in the bank. This is still important. You care about it and your parents care about this as well. So this is question number 2 in your workbook. Who are the people you care most about, and who are you doing planning for? Go ahead and write that down. Just try and keep you guys awake. So this is our agenda for today. You're going to get pretty much the same information you would get in a one-on-one consultation with me. I know that many, if not most of you on this webinar are parents of minor children, but are also helping aging parents. So we're going to talk about the essential documents that both you and your parents need to have in place right now. And as parents of minor children, you also want to make sure that your kids are always taken care of by the people you want in the way that you want if something happens to you. So we're going to talk about that. We're also going to spend a lot of time talking about your two basic estate planning options, including the difference between a will and a trust, and how a trust can help you and your parents avoid probate. So by the end of this webinar, I want you to have an idea of what makes sense for your family. And then finally, I'm going to give you a very, very basic introduction to Medicaid and why you and your parents need to plan for the possibility of long-term care. I'm going to talk for about 45 minutes. I feel like this probably comes in a little bit longer than that. And then we're going to have time for Q&A. So I will stay on after the hour mark if needed for questions. If you need to drop off, that's fine. We are going to send out a recording of this as soon as it's available, probably tomorrow or at least by the end of the week. Okay, and we're also going to go over how do you start the estate planning process with my firm, what's involved, and how much it costs, because I know that cost is a big concern for everyone. So by the end of the webinar, you're going to have all the information you need to make a decision about your own estate plan and how to move forward, just like you would if you're sitting in a consultation with me. I want to make sure that you also know how to start conversations about estate planning with your parents as well. And don't forget, there's a bonus at the very end. Okay, so a little bit about me. Again, I'm Stephanie. I'm an estate planning attorney with Jennifer Porter Law. We are a military spouse-owned firm based in Northern Virginia and Hampton Roads. I've been a practicing Virginia attorney for 22 years, and I'm also a former military spouse. My husband is retired. And here is all of my contact information. You can take a screenshot or take a photo or use the QR code to save my info. And please feel free to call me or email me if you have any questions. So just like many of you, my reason for being here, for doing this, is my family. I live in Virginia with my husband. That's him. He's the handsome guy in the tie and the suit in the middle. He is retired from the Navy. And then we have 3 boys, and you can see them here. One is off at college at Virginia Tech. Our middle just graduated on Monday, and this photo is actually from his graduation. That's him in the white tux there, and he is headed off to William and Mary in the fall. And then my youngest in the bow tie is 10 going on 20. So my husband and I, we have aging parents, and we have college expenses, and we are trying to save for retirement. And we're trying to also make sure that our youngest, who is only 10 years old, is cared for if something happens to us. So I get it. I know how completely overwhelming this is and how hard it can be to know exactly where to start. So today we're going to talk about how to start planning. These are just some of the things that estate planning accomplishes. And I'm going to go through each of these really quickly because we're going to talk about most of them during this webinar. But I want you to think about which of these are the most important to you and your family. So you want your assets to go to the person that you want, the way you want, and when you want. Most people want to avoid probate court, want to maximize your assets and make sure that they actually go to your loved ones and not to the government. You want to care for yourself during your lifetime if you're incapacitated, both in terms of health and finances. Many people want to fulfill a charitable intention at their death. You want to minimize taxes. You want to care for and protect your loved ones, including a surviving spouse and any children or grandchildren that you have. And many people also want to help pass on the values and ideals that they have to their children and their grandchildren. And then finally, we always want to protect assets from creditors, divorce, bankruptcy, or the government. So one of the questions I know that you all have is, what documents do I need to get in place? What documents do my parents need to have in place? Well, here you go. Here's the list right here. Here are all of the essential planning documents you need in place right now. So you need a will or a trust, which distributes your assets. You need guardian nominations to take care of your minor children. You need healthcare and financial powers of attorney. That gives an agent the ability to act for you if you're incapacitated and you can't make your own decisions. You need a HIPAA medical release so the people you care about can get information about your medical condition if something happens to you. And then finally, an advanced healthcare directive, which helps ensure that your wishes for end of life are followed as well. And today I'm going to talk about comprehensive estate planning a lot. A comprehensive planning means not just planning for your death, but for your potential incapacity. So what happens if you and your partner are in a horrible accident and you can't tell your healthcare providers what care you would like? How will your loved ones get information about your condition? Who steps in and cares for your kids? Who's going to pay your mortgage? These are the most important documents to have in place to ensure that you and your family are still cared for in the event of your incapacity or death. Now, these documents are also important for your parents to have in place so that you or other trusted people can help them when they need it. And all of these documents are included in comprehensive estate planning. Okay, so let's step back for a minute and think about what happens if you don't have any estate planning documents in place, which is a situation that a lot of people are in. So at least most people think that they don't have any estate plan because you haven't formally done a will or a trust. But the truth is that you really do have an estate plan, and so do your parents, even if you haven't formally prepared a will. It's just that the Commonwealth of Virginia has written it for you. And also, side note, I'm going to talk about Virginia law in this webinar because I am a Virginia attorney. I'm licensed in Virginia and DC. If you're in another state, this may all be very useful information, but it is also somewhat state dependent. Some of this information is useful in any state, and you are welcome to listen, participate, and ask questions. I cannot help you with a will or a trust, but I can find someone locally for you that can. Okay? So, side note, back to the webinar. So, in other words, there are default rules that kick in if you die without doing any estate planning. You're probably not going to like those default rules, which is why we do estate planning, so you can override the default. And you can make these important decisions for yourself instead of letting the Virginia Code decide them for you. So if you die with no estate plan, without a will or a trust, it's called dying intestate. And this may be the situation that many of you are in now. No judgment here. I know it's hard. This is the doing nothing scenario, and it means you're going to end up with Virginia's default plan. So what is that? In Virginia, if you die without a will, your assets are going to be distributed according to state law. That means that it could go to people that you don't want. Your kids are going to get their inheritance at age 18 outright. They could lose it in a number of ways. And I don't know about y'all, but I have an 18-year-old and a 19-year-old, and the thought of them with a large sum of money strikes fear in my heart. They're good kids, but they just do not have the life experience or the knowledge that they need to care for something like that instead of going out and buying an $80,000 car. Because, y'all, my 19-year-old would totally do that. So other issues that can happen, your spouse can remarry after your death and leave money to a new spouse and kids. A judge is going to decide who will raise your minor children. A judge is going to decide who is in charge of your children's money. And you are absolutely guaranteed to go through probate. Now, if you're okay with the default plan, as I've laid out, you don't really need to do anything. But I haven't actually met anyone who's fine with this happening. So I don't know. So here I'm talking to the parents on the webinar, which is probably most of you, since this is estate planning for the sandwich generation. If you have minor children, kids below the age of 18 in Virginia, one of your top priorities should be getting in writing who you want raising your kids if something happens to you and your spouse or your partner. In fact, I think for parents of minor children, planning is even more important than for people who are elderly, because there is nothing more important than making sure your kids are taken care of by people you want, the way you want, no matter what happens. So the rule is if you have not nominated guardians in a will and you and your partner or spouse pass away, a judge is going to choose for you. In other words, a complete stranger is going to decide who gets permanent custody of your children. And because you didn't get your wishes down in writing, they have no choice but to figure out who you would have wanted on your own. And just writing it in a letter or letting your sister know is not good enough. That is not legally binding. A judge is going to do the best that they can with the information that they have, but they don't know your family. They don't know your preferences. They don't know all the dirty secrets. They don't know what you would have wanted. So this is question number 3 in your workbook. If you don't nominate legal guardians for your children, who's going to name them for you? So a judge could end up naming someone who looks really good on paper, but in real life is the last person you would ever want raising your kids. And this is something that happens in a permanent guardianship proceeding. In a permanent guardianship proceeding, a friend or a family member petitions the court for custody of your kids, and a judge makes the final decision about who is going to raise them. This kind of proceeding is rigorous. It is complicated. It takes a long time. It's expensive, and it is emotionally draining. So you want to avoid this. And the way you do this is by setting up a will. This is the legal document where parents nominate guardians. Another reason you really want to get your wishes in writing in a will is because what if more than one family member wants custody of your kids? I mean, that's a good problem to have, right? What if your sister wants custody, but also your husband's parents do? And I hear this a lot. Clients come to me and they say, I don't think it's a problem because there are so many people that want our children. It would be fine. Someone would take care of them. And this actually becomes a problem because family members will fight over your children. It's great that you have so many people who love them, but if you haven't said which of those family members you prefer and in what order, families will fight in court for your kids. And your kids are stuck in the middle of that. It's not a situation that you want. So your solution is to do a will. You name your first choice for guardians for your kids. If it's a couple, you want to say what happens if they get a divorce or one dies. You might name your sister Jennifer and her husband Tim. But if Jennifer dies, do you want the kids going to Tim? Maybe, maybe not. So you're going to write that down. And then you can list as many backups as you want, just in case your first choice is not available or they decline the appointment. Okay, now we're going to talk about the money, your actual estate. Who gets your money when you pass away? If you want to leave everything to your cat, that is absolutely an option. But let's talk about the other options. So first of all, what do I mean when I say estate? Because, that sounds intimidating, and many of us don't think we have an estate, that only really wealthy people have estates. But all of us have some of these assets or accounts. You've got a bank account, a car, a house, a retirement account, intellectual property. Maybe you've got a great coin collection. Maybe you have a small business, life insurance proceeds. All of us have some of these. And we need to decide where all of this is going to go when we pass away and under what circumstances. Now, there are 3 ways that you can own property at your death. And this is question number 4 in your workbook. You can own them individually, jointly, and with a beneficiary designation. So a bank account that you own alone, not jointly with anyone else, is owned individually. A bank account that you own with 2 or more people, like a husband and wife, is owned jointly. And an asset like a life insurance or 401k has a set of instructions, a beneficiary designation that tells you where it goes when you're gone. So this is the key. You still need to do estate planning, even if everything you have is held jointly with your spouse or it all has a beneficiary designation. And you may be thinking, I don't need to do that. We own it jointly. It's fine. If I die, everything just goes to them. And that is absolutely true. Jointly held assets do go to your other owner when you pass away. But we also have to account for what happens when the second owner dies, or if you die at the same time. It happens a lot, unfortunately. So jointly owned assets avoid probate when the first of you passes away, but they will not avoid probate at the second death. And we're going to talk a little bit more about probate in a minute. So similarly, if you have only one parent left, Many of their assets may no longer be jointly owned, and you could be dealing with probate when your remaining parent passes away. Sometimes some accounts like life insurance also have a built-in estate plan, and this will just get paid to whoever you've named as the beneficiary when you pass away. So generally those assets don't have to go through probate, which is great. But that is assuming that the beneficiary is over the age of 18 and actually alive when you pass away. If they are not, there's no remaining beneficiary, those assets have to be probated. And just as important is that the proceeds will be paid outright. So if you've named your 19-year-old son, like my 19-year-old son, as the beneficiary on your $500,000 life insurance policy, do you really want him getting a check for $500,000? I mean, I personally, as an attorney, I'm going to tell you, don't do that. You need some rules about how and when he can spend the money, okay? So he doesn't blow it all. A better idea is to set up a trust, name the trust as the beneficiary instead of your adult children, and then put some rules in place as to what they can spend the money on. Okay, so hopefully you understand that you now need an estate plan no matter what assets you have. So what are your options? And as we go through these two options, I want you to think about which one makes sense for you and your family. You have two options. You're either going to do a will-based estate plan or you're going to do a living trust-based estate plan. And this is a decision that everyone has to make, whether you're married or single, kids or no kids, regardless of how much money you have to decide, do you want to do a will or a trust? If I didn't mention it earlier, I will now. The vast majority of my clients and people today choose to do a trust instead of a will, but I do want you to understand both options. So that is question number 5 in your workbook. Go ahead and write it down. So let's look at a will. What does a will accomplish? Having a will is a great start. If you have one in place, go you. I'm so proud of you. This is where you name guardians for your minor kids. You can name beneficiaries for any assets or account held in your name alone, and you can name an executor. So this is the person who's in charge of wrapping up your affairs and estate when you're gone. So side note here, in Virginia, we call this a personal representative because I don't know, we want to be different, but I'm just going to use the term executor over and over because I feel like most people know what that is. So those are the things that your will is going to accomplish, and it's about all that a will does. You can see that a will doesn't actually accomplish all that much, and it does come with some downsides that I think many people are unaware of. So the downsides to a will. First, as I mentioned before, wills have to go through probate court at your death. And we'll talk about why this can be a bad thing in a little bit. Your will is only effective at your death, so it does not help you at all if you're alive but disabled or incapacitated and unable to manage your own affairs. So what happens if you can't pay your bills or communicate your healthcare wishes? Your will is not going to help at all in those circumstances. And this is a situation that happens to most people at some point. So it's something to think about. And also, each state has their own laws regarding wills. And this is a problem that I know military families run into a lot. A Virginia will may not necessarily be effective in California or Florida because of the way that property is distributed or the legalities surrounding the signing. So if you do a Virginia will and then you move, you may have to redo your estate plan. Most parents don't want their kids to inherit everything when they turn 18, which is the age you are legally entitled to inherit money. I think that most parents want their kids to get a little bit later in life when they are a little more mature. And you can't really do much about that in a will. You can't put instructions in your will that say my kid can only inherit if they are 25 and have finished college or trade school. You just can't do that in a will. You have to have a trust if you want to do that. As I said before, most assets are outside of the reach of a will and they go unplanned for. So wills don't control most property, including retirement plans, annuities, insurance policies, anything that you hold jointly with someone else. And then finally, a will simply transfers property at death. You can say, I want my money to go to my daughter when I pass away, but you can't say when she's 25 and has finished college or started a business or gone to trade school. You can't put any instructions in a will for how or when the money is spent for your kids or for grandkids. You need a trust to do that. And as I've mentioned probate several times, and when there is a will, there is probate. This means that if you die with a will, it must go through probate court before your money can be distributed to your family. And while your court experience probably won't be as traumatizing as Colonel Jessup's, it will not be pleasant, probably, because court is never a very fun process. So what is probate? Basically, the main purpose of probate is to change the title on all of the property that you own when you die from you to your family. So your executor will do a full inventory of your assets and appraise each asset. If anyone contests the will, that happens in probate court, and the judge will settle the disputes there. And then the assets are distributed to the rightful beneficiaries. This is overseen by a judge, and you need court permission to distribute anything. And for most people, your family will have to hire a lawyer because it's a complex process. There are 3 big downsides to probate court. It's expensive, it can take a long time, and it's a public process. And this is question number 6 in your workbook. So there are a lot of fees that go with probating a will. Court fees, legal fees, executor fees, and they can eat up as much as 1 to 5% of your estate assets. These fees are going to reduce the amount of money that ultimately goes to your family. So let's look at a real world example here. Rebecca is a single woman. She has a will leaving everything to her daughter, Megan. Megan is currently 10 years old. Rebecca has a house that she lives in that's worth $400,000. And also a house she rents out that's worth $100,000, though it must not be in Northern Virginia. She's also got an investment account with $250,000. She's got life insurance payable to her minor daughter and a retirement account payable to Megan, her minor daughter. And because minors cannot inherit property directly, these assets now have to go through probate court, even with a direct beneficiary. So a judge can make sure that this money is being handled properly. So these assets, all of these assets are now part of her probate estate. When we add it up, the total probate estate is $1.8 million. Now remember how I said earlier that probate can cost as much as 1 to 5% of the probate estate? When Rebecca dies, her will leaves everything to Megan, needs to go through probate court. Her family's going to have to hire a lawyer to probate the will and handle a conservatorship for a minor, because kids under 18 can't just inherit outright. So let's say it only ends up costing 2% of the total estate, which is a conservative number, because remember, conservatorship is in place until she is 18. So that's 8 years. But 2%, let's say 2%, that's still $36,000 lost in probate. This is $36,000 that is not going to Megan. It's going to lawyers, courts, and probate fees. So this is a pretty big downside to dying with a will that most people are completely unaware of. The cost of probating a will at death can be significant, even for middle-class families. The second downside is that probate can take a long time. Even a simple estate in Virginia can take months or years to probate. The minimum under Virginia law is typically 6 months, but that never happens. Your assets are frozen for the duration. In Virginia, it's going to be 12 to 18 months. And this can be a problem if you're counting on money being available for the care of your minor children. If you've got a guardian who's not able to, float those costs in the meantime, that can cause a hardship. It's an emotional burden for your family and a financial burden that drags the process of settling your affairs out over several years. If you have minor children, the court is going to oversee their money until they are 18. This drags on for years, and it's not fun. So I think many people would agree that there are few things more private than your relationships with your loved ones and your finances. But the third downside of probate is that if you die with a will, your estate is going to be a matter of public record. This means anyone can go down to the courthouse and find out what assets you left behind, how much they're worth. So you can end up inadvertently sharing very personal information with anyone who cares to look. And this can make your minor children vulnerable to all sorts of unsavory individuals. It can also make your parents, your elderly parents, vulnerable because their names are in your will and something happens to you, right alongside with how much money they're going to be inheriting, when they're 18 or now, that can be a problem. And more, we're seeing scams pop up for things like that with people who have recently inherited money. So this is the third downside to probate court. And I want you to think about which of those three bothers you the most, the cost, the time, or the public nature of it. So now you're asking yourself, knowing all of this, why would anyone do a will? And I am asked this question all the time once people see the downsides. And the answer is that if you have less than $50,000 in assets when you pass away, you're eligible for a simplified probate process that's easy and inexpensive. So in that case, a will may be sufficient. But if you have more than $50,000 and you want to avoid any of those three downsides we just discussed, a will may not be the best choice for your family. So you're going, okay, so if a will isn't going to do what I thought it was going to do, what's going to fix all these problems? So let's look at your second option. And this is to do something called a revocable living trust. And again, this is the option that probably 90% of my clients choose. What is a revocable living trust? It's kind of like a will on steroids. It's a legal document you create similar to a will. You list the people you want inheriting your money when you're gone. And just like a will, the trust is revocable. That means you can change it or even revoke it entirely at any time. And your revocable living trust is going to have a trustee, and that's you. You're in charge of both the trust document itself and the assets that go into the trust. So the way that it works is you create and sign the trust document and you give it a name, maybe the Jones Family Trust, and everything you own is now outside of that trust. You want to move your assets into the trust by retitling them. Remember, we talked about title earlier. So keep in mind that you still have total control over the assets that are in this trust. You can still use them. You can still spend them, sell them. Nothing changes. You do your taxes exactly the same way as individuals. But the benefit is that everything inside the trust goes to your named beneficiaries without having to go through probate. And this is information that most of my clients didn't even know. They're like, I thought a will did all of that. No, it doesn't. Most people just aren't familiar with trusts and what they can do, but it's great information to have. So the other question I get is, aren't trusts for rich people? We've all heard of the trust fund baby. And if you're thinking that, you'd be wrong, because trusts are definitely not just for wealthy people. Simply put, a trust is an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away. That's it. So put another way, a trust solves all of those problems that people assume are solved by a will. So let's look at another example. This is Bob. Bob has $100,000 in a bank account that he wants to go to his daughter, Ava, when he dies. But he wants Ava to be 25 and to have finished college before she gets the money. Bob needs a trust. Bob is not wealthy. He's not setting up some fancy trust because he's leaving millions behind. He's just putting some rules in place because he wants Ava to be 25 before she inherits, and he wants her to finish college. It's very important to him. So Bob needs a trust. Even though he doesn't have a lot of money or a complicated estate, he needs a trust because he wants to control how and when his daughter gets his inheritance. And that's it. Now, every trust has three roles. It has a settlor or grantor. In Virginia, we call him a settlor. Everyone else calls them grantors, again, because we have to be different. And this is the person who contributes assets to the trust. So if, all of you on this webinar create a trust, you are the settlor or the grantor. The trustee is the person who manages the trust assets, and the beneficiary is the person who is entitled to the assets. And with a revocable living trust, you hold all three positions while you're alive. You're the grantor, the trustee, and the beneficiary while you're alive. So here we have Harry and Wendy, Harry husband, Wendy wife, and they set up a revocable living trust. They occupy all three positions. They have total control. They act as the grantors. They created the trust and they transferred title to their assets into the trust. They occupy the manager's role as trustee. They make all the decisions over assets. And then finally, they're also the beneficiaries of the trust, and they can spend and use the trust assets any way they want. So in other words, Harry and Wendy still have complete control over their assets, even though the assets are titled in their trust. And what does it mean to be in total control? It's just business as usual for Harry and Wendy. They can amend their trust or even revoke it if they want. They have all rights to manage the property, and their income tax forms are filed exactly the same way they've always filed them. And the property taxes on their home are paid in the same way as well. And because this is a revocable trust, the government pretty much ignores the trust for tax purposes and continues to tax Harry and Wendy as individuals. And there's even a section of the IRS code that says this specifically. So you're protected. With the revocable living trust, the secret to avoiding probate is how you hold title to your assets. And we touched upon this already. Remember how I talked about assets being owned individually, jointly, or with a beneficiary designation? Well, that comes into play here when we talk about revocable living trusts. Question number 7 in your workbook. Think of a revocable living trust like a kid's backpack. When your kids start school, they pick out a backpack, and it can be any kind, any color, size. There's a million different options. Your trust is the same way. You set it up so it accomplishes what you want it to accomplish. The goal is to have your trust hold all of your assets, because then those assets will be distributed according to the terms of the trust when you pass away. So your trust document is like the backpack. You set it up how you want it, and then you move all of your assets into the trust, into the backpack. And then when you pass away, everything held by the trust goes to your family without any probate court involvement. So right now, all of your assets are in your name, which is bad. You want all of your assets to be in the name of your trust. In other words, you want all of your assets to be inside the trust or inside the backpack. Now, funding your trust is simply changing the ownership or retitling your assets so the trust owns them instead of you. Just like this woman loading up her backpack, you're going to put all of your stuff into your trust. And don't worry, we give you guidance on that. So a trust solves all of the problems that come with a will. You're not going to lose, 1% to 2% or up to 5% of your estate in probate court. Your assets can go to your family in weeks or months instead of years, and it's private during your life and at death. There are some other benefits to the living trust. It's pretty easy to amend as your life changes. You can make changes to the trust document very easily. The trust doesn't have a separate tax identity. So like I said before, income taxes don't change at all. Your trust can cover all of your property, including beneficiary assets and jointly held assets. And it's the process to create it is about the same as doing a will. It's valid in all 50 states. So if you move, you don't have to necessarily redo your estate plan every single time. And because it's a private document, nobody's going to know what's in it. So it's harder to contest. As part of your trust planning, we also discuss strategies for managing an inheritance, gift and estate taxes, and protecting assets for your children and grandchildren. So the next question. If you do the revocable living trust and not a will, where do you nominate guardians? Because I just said that you needed a will to nominate guardians, right? Well, the answer is when you do a revocable living trust, we also do a very basic will that goes with it, and it's called a pour-over will. And it basically pours any asset that's not in your trust at death, maybe by accident or intentionally, and it pours it into your trust. So it's like a safety net. But we also use the pour-over will to nominate guardians. So I'm going to talk really quickly about estate taxes because every single person that I talk to about estate planning asks about taxes. So, estate tax is a tax that's due when someone passes away if they have more than a certain amount in assets, not just money, like everything is included in your taxable estate. So, there is a federal estate tax, but in Virginia, we do not have an estate tax anymore. But if you're married and you die with more than $27.2 million in assets, your state will have to pay federal estate taxes. And if you are on this call and you have more than 27.2 million in assets, can you please adopt me? Thank you. Anyway, I have an asterisk here on that amount because that amount may revert to $5 million per person adjusted for inflation if Congress doesn't renew the legislation that makes it $27.2 million by the end of 2025. And I think we all know that Congress finds it very difficult these days to get anything done. So I am assuming that it is going to revert back to 5 million per person at the end of 2025. So even if this isn't something that affects you right now, it may affect you in the future. And things can easily change in terms of estate taxes. 20 years ago, the estate tax was only about $1 million. So think about that for a minute. Yeah. And you're adding up numbers in your head and you're going, oh, whoa. Yeah. So this is something to just keep in mind and to be aware of. If you're in this category, you can reduce the tax liability by doing more advanced planning. That's beyond the scope of this webinar right now, but this is something that may affect you in the future. If it doesn't now, as property values increase and as your investments grow with age. Okay, parents. I know that many of you on here also have aging parents, and you're concerned about how you can help them and protect them as they get older and develop health issues. So this is a seminar that I could do all on its own for literally an entire day, 12 hours. But there are 3 essential steps you should take with your parents to tackle this problem head on. And I know this is a really hard conversation to have. First, sit down and talk to your parents about what they have in place. Do they have a will? Do they have powers of attorney? Have they thought about it? Number 2, encourage them to write down their wishes as they age. But that's really not enough. They do need to make it official, but it is a good start. And then 3, finally, help them find an attorney if they need to make a plan. If they don't have anything in place, they definitely need a plan. If you have parents in Virginia, I can help them. But if they're in another state, you can reach out to me as well. I belong to a nationwide network of estate planning attorneys, and we may be able to help them find someone local to them. If your parents also need help understanding why they need an estate plan, we're going to send out a recording of this video. So you can send it to your parents, or you can sit down and watch it with them, because I find that having a neutral third party bring up these topics makes it easier for you to start that conversation with them. Okay, long-term care. This is another topic that we could spend days on by itself, but it's something that many people ask me about, whether they're concerned about themselves as they age or they're concerned about their aging parents. So the first thing that it's important for you to know is that Medicare, the healthcare plan we're all entitled to it at 65, does not cover most long-term custodial care or long-term services and support. These are things beyond medical care. So long-term care can include like adult day care, an assisted living facility, or help with activities of daily living, like dressing, using the bathroom, preparing food. If your parents need skilled care, Medicare only covers a very limited time period. And after that, the patient must pay 100% of the cost. Second, long-term care is expensive. The average cost of a nursing home in Virginia is $221 a day, which is more than $80,000 a year. So obviously that depends on where you live, but here are some averages for you. In Norfolk, the average is $74,000 a year. In Roanoke, $88,000. Richmond, $94,000, and in Northern Virginia, $116,000 a year is the average. Most people just cannot afford that, or they're going to be broke in no time at all. Many people end up spending everything they've worked for over years so that they can qualify for Medicaid, which does cover some long-term care. But Medicaid has very strict income restrictions. In Virginia, if you are 65 or older, you cannot qualify for Medicaid nursing home care if you make more than $2,829 a month, or if you have $2,000 or more in assets. And no, there are no zeros missing from that. $2,000. Now, Medicaid is not going to make your dad sell the house if your mom is in a nursing home. But when your dad dies, Medicaid will have a claim on that house for everything they've spent. And this is shocking for most people who haven't looked into this. So what's the solution? What can you do? There is no perfect answer, but there are some options, including obtaining long-term care insurance, which I highly recommend for anyone, and 2, asset protection planning with an estate planning attorney. Now, this can get complicated. You just can't wait until mom or dad needs a nursing home and then put everything in an asset protection trust. That is not how it works. Medicaid has a 5-year look-back period. So if, mom and dad decide, oh, we're going to give you the house so they can't take it, and then mom goes in a nursing home 2 weeks later, no, Medicaid is going to claw that house back. Similarly, they can't just, start a trust, put everything in it, and then go get the care. Medicaid is going to claw that back. Everything over the last 5 years. So asset protection planning is something you need to do earlier rather than later. All of these options are beyond the scope of this webinar just because it is so complex. But please, if you feel like this is something you need, feel free to contact me and we can chat. So all of these conversations are very hard to have with people we love, but I wanted you to see how financially devastating failing to plan can be. So this is another question I get a lot. Can I just make my own will or trust online? And I think DIY is great for crafts if you are a crafty person, but I would not recommend tearing out your walls and trying to fix your own electricity. And it's the same way for estate planning. Cookie cutter plans just don't always work. So let's talk about online estate plan forms. I call these cookie cutter plans, and I am asked about them all the time. And this is why it's important for you to understand what comprehensive estate planning is. It's not just a document, it's comprehensive. Some people utilize online or cookie cutter sort of fill in the blank estate plans, if you will, and they don't always work when you need them to. What I've seen after doing this for a while is that cookie cutter documents are poorly drafted. Often they don't even comply with Virginia law, and they don't address real life issues that families face. Like if you've got a blended family, you have kids with special needs, long-term care planning, not addressed at all, estate tax issues. They're very cookie cutter and they don't address the things that you really care about. They also don't address things like what happens if someone is disabled in the future? What happens if my children die before me? What happens if when I die, my wife does need Medicaid? Cookie cutter plans, they don't address that at all. And most of those documents that you get online are just a will and testament. And that's what most people think of when you think of estate planning. But the problem with a will is that it guarantees you're going to have to go through probate before getting access to your assets. And when you just have a will, it's not comprehensive. You need to plan for incapacity as well. So all of those documents that we talked about, the healthcare power of attorney, the financial power of attorney, they allow people to help you and to help your family in the event that you're incapacitated. The cookie cutter plans just don't do that. They also aren't going to keep up with your life. They're not going to contact you if the estate tax sunsets back to $5 million and your assets are pushing up on that. They're not going to do that. LegalZoom's not going to give you a call or send you an email. And most of those cookie cutter estate plans also just leave the money outright to kids at 18, which we know can be a problem. So this is why you need to work with a lawyer who will take the time to do comprehensive estate planning. Another recent trend that I'm seeing are things that I call bare bones trusts. And most of the legal community calls them this as well. So you could even Google them and see what they are. But estate planning should be done by an estate planning attorney who is committed to providing a comprehensive estate plan. There are less qualified options available for families that may not know better. They're produced by attorneys that maybe don't focus on estate planning. There are employer-provided discount legal plans, and sometimes even non-attorneys. So watch out for these documents because, again, they may not comply with state law, and they won't contain the important personalized information and planning that's needed to protect you and your family. And also, they're typically not funded, which means the trust is set up, that backpack is there, but the assets were never moved into the backpack. And because they're not funded, the estate will still be required to go through probate. So I don't recommend doing a bare bones trust or trying to do it yourself. A better idea is to work with a lawyer. And here is what I want you to remember. When you work as an attorney, you are paying for guidance and counseling about how the documents should be drafted, not the documents themselves. So when you talk to me, I'm going to look at your situation, your family situation, your concerns, and your life. And that's what my recommendation will be based on. So the information portion of the program is over. And if you have questions, feel free to go ahead and put them in the chat while I go over the last steps. So now we're going to talk about getting an action plan in place and then these basic questions. What do you need to do? How do you make it happen? When should you get started? And what is the investment to get it done right? So if you worked with a lawyer before, you may be familiar with the billable hour. This means an attorney keeps track of how much time they spend on your matter in 6-minute increments. It's interesting. We joke that attorneys are bad at math, but they're really good at adding by 6. So this can be really stressful because you don't know how much it's going to cost when you hire an attorney. Excuse me. Also, the traditional practice of law is very reactive. Problem falls in your lap, you're reacting to the problem, and you're trying to put out an expensive fire. And ultimately, you're a number. Your matter starts, your matter ends, and then you don't have any ongoing guidance on how to avoid problems in the future. Well, we sort of flipped that traditional experience on its head. Everything that I do in estate planning is flat fee, and it's agreed to in advance. So you don't have to worry about being charged for every time you call me or email me because we don't keep track of your time. And you may have a million questions about your plan. And I promise you, I have clients who do. And that is all part of your flat fee. And also, we love creating estate plans for our clients because it's very proactive. We're not responding to negative situations. It's all about you and making sure your family won't have to deal with an expensive mess when you're gone. And I really value my relationships with my clients. I want to stay in touch with you over time because I know that your estate plan is not something you do once and then never think about again. Your life is going to change and the law will change. And I want your plan to keep on. So this is our virtual estate planning process. First, you attend a peace of mind planning session, which is a one-on-one consultation with me that lasts about an hour. This is $400. But we apply this $400 towards any estate planning work we do for you. So before the session, I ask you to fill out an online questionnaire at least 3 days before the meeting. And this has questions about your family and your assets so that we can start to gather the information I need to draft your documents. And in your planning session, I hear more about your goals and concerns. We'll look at your personal and financial situation, and then I'll explain your options thoroughly. And that way you can make the best choice for your family. And after you've decided to hire us for estate planning, we have a design meeting. We'll sign your engagement letter. We take payment for your package. And then we actually sit down and design your estate plan together. Then I draft your estate planning documents. I send them to you for review. We meet again and we go over your documents. And I explain what all of that legalese means. You ask questions, we make adjustments. And once we finalize your documents, we pick a date to sign everything, and we typically do that in person at our offices in Fairfax or in Norfolk. And then you have a legal estate plan. Yay! Finally, we invite you to keep in touch with us. So we'll send you information from time to time about estate planning, and we'll ask you to check in when you have major changes in your life. So if you get married, divorced, have a big increase in income, win the lottery, start a business, close a business, it may be time to adjust your estate plan. So either way, you should reassess at least every 5 years. And then if you have changes to make, we can do that for you too. And then I quote a fee at the time based on your needs. Okay, packages and fees. Let's talk about that. So bargains are good for paper towels, but going cheap on a parachute, a surgeon, or a fire extinguisher could be devastating. So estate planning is like anything else. You get what you pay for, and it's worth it to make the investment to get it done right. Frankly, not planning is going to cost you a lot more than working with us will. So planning could save your family anywhere from $12,000 to $25,000 or more if you have more assets. And it helps save a huge nightmare. Even if you only own a house worth $500,000 and you have minor children, working with us is financially the right decision to do. And it can save your kids from losing their entire inheritance in a lawsuit in the future. I mean, that's something we can talk about during planning session. The good news is that our estate planning packages are substantially less than that. Then the whole point of this is to save you and your family time and money over the long term. We offer 3 levels of protection: the basic plan, peace of mind plan, and the platinum plan. We find that most of our clients fall into one of these 3 categories, and you can decide which level of protection works for you. The basic plan is for people who want a last will and testament. This makes sense if you have less than $50,000 in assets or you don't care about probate avoidance. So the fee for the basic plan is $3,500 for a married couple, and this includes planning for both spouses. The second level, the peace of mind plan, includes additional protection, including a revocable living trust and a children's trust if you need it, which is something we can talk about during a planning session. But that is something that helps protect the inheritance of your minor children, because remember, they can't inherit outright until they're 18, or adult children from divorce, lawsuits, or overspending. The peace of mind plan is $5,000 for a married couple, and this includes planning for both spouses. And finally, to avoid protection or to add protection from estate taxes, we also offer this platinum plan. This level is the broadest protection possible, and it's hard to quote an exact number because everyone's estates are so different. If you have parents who need asset protection planning as well, the fee might be different than the basic $5,000. But I want you to have this information so that you understand how much the cost is before you get started. So I'm going to talk about the peace of mind plan because that is what most families end up in. So the peace of mind plan has everything that you see here for both spouses if you're married. If you are single, you can take $500 off this. It will be $4,500. It's $500 off of each plan if you're single as opposed to a married couple. So in here, we have all of those documents that we talked about being essential to get in place right now. This includes a revocable living trust, the pour over will, which pours over into your trust at death. And that's where your guardians are named. We can do a children's trust if you need it. Remember how earlier I said estate planning isn't just about planning for death. It's also about planning for your incapacity. Each spouse gets a power of attorney for their finances. You pick someone who can pay your bills and manage your accounts if you're incapacitated and can't do it yourself. And same for the healthcare power of attorney. You have, if you can't communicate your healthcare decisions, you have an agent who can do that for you. You also get a HIPAA waiver, which I know we're probably all familiar with because we sign them at the doctor's offices all the time. But this gives your healthcare agent permission to speak to doctors on your behalf. And then a living will, which is also called an advanced healthcare directive. And this outlines your end of life wishes. If you have minor kids, we are going to name guardians both inside and outside of the will. We include an explanation of all the documents, instructions on how to title your assets to your trust. You get a certified copy of your trust, instructions for your successor trustee to reference when you pass away. And we provide instructions for your loved ones relating to burial, cremation, anything that you have. And we give you a nice big binder with all of your original signed documents, and we give them to you electronically. so that you can save them in the cloud in multiple different places and send them to people who need them. If you are ready to move forward, the next step is to book your peace of mind planning session. And you can do that by calling our firm, or you can email me. My email is right there. Or I or one of our paralegals can set up a time for your peace of mind planning session. And if you have any questions at all and you want to have a chat before we do that, we can have a 10-minute call after this and go through any of your questions before we book the peace of mind planning session. So just contact me right away and I am happy to help. I'm going to leave that up there for just a minute while I read through the questions we got so far. Okay. So Kayla asks, if one person in a married couple dies, can they ignore the terms of the irrevocable living trust? For example, spend all the assets you want to be waiting for your minor children at age 25. The answer to that question, Kayla, is it's complicated. Yeah, there are options to avoid that. So normally when you have a revocable living trust that you set up jointly with your spouse, when one spouse dies, the other one, they're the only one left. It's still revocable. They can change the trust. They can revoke it. They can leave the assets to someone else. They can take assets out. They can do whatever they want. But we can design a trust so that upon the death of the first spouse, the trust splits in half. And the remaining spouse has their half of the assets. And then the other half of the assets are in this trust that the remaining spouse can't spend for the benefit of those children. You can set it up any way you want. Maybe they get the income from that while they're alive. But then when they die, that goes to your kids. And that's always a good, if you're concerned about a remarriage, you'll always hear about people unintentionally disinheriting their children in a remarriage. This can avoid that. So it is possible to avoid that. That is an excellent question. Okay, let's see. What is the difference between a revocable and an irrevocable trust? Okay, so that's a good question. When I mentioned an asset protection trust that you use for Medicaid, that's an example of an irrevocable trust. The difference is that an irrevocable trust, once it's set up, it can't be revoked. The assets that are in it stay in there. You have to follow the terms of the trust. There's a trustee who's in charge of doling it out according to the instructions, and it can't be revoked. It can in some very limited situations, but because, everything is gray in the law, but that's the basic difference between irrevocable and an irrevocable trust. And there are literally thousands of different types of irrevocable trust used to set up for specific, like special needs trusts are irrevocable. Medicaid planning trusts are irrevocable. If you wanted to set up something so that your children can't spend their inheritance or, their spouse can't take it in a divorce, that would be an irrevocable trust. So that's the basic difference. Okay, I'm also getting some messages here, which are not in chat. So let me look at those real quick. Can I put my house into a trust if it has a mortgage? That is an excellent question. You can. Yes, you can. There is actually federal legislation that protects you. When you have a mortgage, there's a due on sale clause. So like if you sell your house, you have to pay out the mortgage right away, with the proceeds. If there are certain other things that happen, your mortgage company can say, oh, you owe us all the money right now. And that did happen for a while. There were mortgage companies that when couples would put their home into a trust would say, that triggers the due on sale clause. You need to either refinance at a higher rate now, or you need to pay us all of that. So Congress actually passed some useful legislation. And there is a law that protects you when you move your home into a revocable living trust. Even if you have a mortgage, the bank has to honor that, and they can't force you to refinance. So you're good. Okay, and I think that is it for the questions. So we are going to go ahead and wrap this up. Thank you all so much for participating. I really appreciate it. And we will send out a recording of this within the next few days. And in the meantime, if you have any questions, just email me or give me a call. Bye.